the matter of Tecnimont S.P.A. and another and LLC Eurochem North-West-2.
Yes, Mr. McLean.
My Lord, I appear with my learned friend Mr. Tom Leary for the appellant in this matter.
Yes.
My learned friends Mr. Fennick KC and Mr. MacDonald appear for the
Yes.
respondent. My Lord, before we get started, I think there are two matters of housekeeping.
Yeah.
One has come essentially, I think, really from the
One
court.
what?
One has come essentially from the court about confidentiality. There was an order made before Mr. Justice Henshaw.
Yeah, why?
I'm not sure, my Lord. And I've had a word with...
This is not an arbitration claim. This is a claim for an injunction heard in public court.
My Lord.
Why? Why should anything be confidential?
I've had a discussion with my learned friend before your lordships and your ladyship came into court.
And it's far too wide anyway.
Well, can I just say, I don't want to violently agree with your lordship. Certainly no one's suggesting that there's anything other than public justice. No one's suggesting you should be sitting in private. The bundle, supplementary bundle B, has been treated as confidential, but as your lordship will see from looking at it, there's not much in there that could be confidential. I suppose
there are no trade secrets or confidential financial matters.
Well, it's true that there's a decision in there of the emergency arbitrator, and there's a request for arbitration, and there are also some contractual terms. For my part, I don't propose to take you to the decision of the confidential of the emergency arbitrator or the application.
All right. Well, as you see, there's a certain amount of resistance to making an order in the blanket terms in which it's sought.
I entirely see that, my Lord. And that being so, I won't say any more about it other than to note the issue is there. Well, the other matter is that my clients made what I regret to say was a very ham-fisted application last week to introduce some further documents into the supplementary bundle, which were described as background. They're not background, they're foreground. And we have issued a renewed application for those documents to be
This
included.
is essentially the transcript in front of Mr. Justin Butcher.
Well, it's three things. It's essentially three things, my Lord. First of all, it's the skeleton argument from my learned friends before Mr. Justice Butcher at the ex parte hearing.
Yes.
Secondly, there's a note from Hogan Lovells which records two things. It records the note of the argument,
yes,
and it also records his judgment, his
yes.
reasons. And then thirdly, there's the skeleton argument, which is very similar, and I don't spend any time really on that. The skeleton which they then put in for the return date before Mr. Justice Bryan, when, as your lordship and your ladyship know, the order.
But our starting point surely is the judgment of Judge Pelling.
Well, no, my lord. No, the starting point is the decision of Mr. Justice Butcher, which is when the anti-suit injunction was originally made. Because Mr. Justice Pelling, well, I'm going to deal with His Honour Judge Pelling's judgment. My lord, in order to understand what the order means, one has to look both at what Mr. Justice Butcher said in his reasons, because he was the one who, as it were, started the ball rolling. So, my lord, I've got that application. My learned friend's position is, as I understand it, one of studied neutrality as to this application. I do submit that it's relevant and important for the court to see Mr. Justice Butcher's judgment and the hearing at which he gave the anti-suit injunction. And I seek the court's indulgence to show your lordships, not all of it, but relevant extracts in the course of it.
So does this go to 1C, ground 1C?
Ground 1C.
Which of your grounds does this go to?
It goes to ground 1. It goes to ground 1B and C. Yes, yeah. Essentially, well, it goes to both. What is the scope? The central issue here is what is the scope? What's the proper meaning of the anti-suit injunction? And we say in ground 1B that what's happened in Italy is not within the scope of the prohibition and the anti-suit injunction, properly understood. And then secondly, we say that it's really the same point. It can't have that scope because the arbitration and jurisdiction clauses couldn't have justified an injunction. In other words, if one says to oneself, if the other side had been in apprehension, not of what had happened in Italy before, but there was an attempt to stop payment of the bonds in the previous contract, which you have seen in your reading. But if the only apprehension of the other side had been that my clients were going to intervene in public law proceedings such as these in Italy, and had come for an anti-suit injunction on that basis, they wouldn't have got it. That's really ground 1C. The ground 1B is that the proper scope of the order isn't as broad as my learned friend said.
And your point is that if we were to look at Mr. Justice Butcher's judgment, we would understand that that was not the purpose of the injunction.
You would understand what the purpose was, which was to protect the integrity of the jurisdiction clauses which are in the bonds, principally, and as a fallback position, it was a fallback position of those appealing for the other side before Mr. Justice Butcher, that, well, anything, their primary position was anything that's likely to happen in Italy will trespass on the toes of the jurisdiction agreements and the bonds. We'll see that it was contemplated that any proceedings in Italy would have to join the banks as parties, and which is what had happened previously. So their primary position was, what we fear my clients are going to do will be in breach of the jurisdiction clause. Then they said, but if that's not right, then it will necessarily fall within the arbitration clause as a fallback position. And Mr. Justice Butcher deals with both. We'll then see that His Honour Judge Pelling upholds the anti-suit injunction on the arbitration basis, not on the basis of the jurisdiction clauses or any quasi-contractual claim in relation to them. We'll see that.
Well, I see why you say it's relevant. What do you say, Mr. Fennick?
My Lord, it seems to us it is an attempt to go further and further back in order to see if there's any reason why the words don't mean what they say. But if it helps your Lordship to see them, I'm not going to object.
Let it in. Let it in.
Yeah.
Let it in. All right, we'll let it in.
I'm very grateful. The next question
Not
is...
saying that we're going to do much with it, but we'll let it in.
No, I understand. The next question then is whether the court has that material in front of you.
I think so.
Electronically.
And with page numbers which roll on from the existing supplementary bundle, I hope. But we'll cross that bridge when we come to it.
Yeah.
I'm not sure that I do have that material, I'm sorry.
Well, we've got a hard copy available, which we can hand up to your Lordship if necessary. So, my Lord, my Lady, can I then embark on the substance of the argument? At the heart of the question we submit is whether Tecnimont was in breach. I use Tecnimont to refer to both appellants. Nothing turns on the distinction between the two.
No, but it's important to be accurate. It was Tecnimont that was found to have acted in breach.
Yes, it was.
Tecnimont that brought the application to vary.
Your Ladyship's right.
And it was the application for which was against Tecnimont.
That's right. We can forget about, essentially, LLC Russia for most purposes.
Okay.
The issue is whether Tecnimont was in breach of the anti-suit injunction originally made by Mr. Justice Butcher, continued by Mr. Justice Bryan on the 23rd of August 2022, and further by His Honour Judge Pelling in September, by attempting to participate in Lazio proceedings, which are public law proceedings concerned with the question of whether an Italian subsidiary of the Eurochem Group is owned, held or controlled by a designated person. The Italian authorities have concluded that the Eurochem entity is so owned, held or controlled because it's owned, held or controlled by Mrs. Melnichenko, who has been designated under the EU sanctions regime. Now, the order of Mr. Justice Butcher, the court's got in the supplementary bundle at page 1, tab 1, and the relevant order is at page 2. It's set out in all sorts of skeletons. I'm sure you've got it in various ways. But if you turn to bundle 1, tab 1, and you see the injunction at page 2, paragraph 1. I'm not going to read it out unless the court wants me to. You can see what it says, and we'll come back to these terms, obviously, in the course of the argument. That was then continued by Mr. Justice Bryan, and his order is at tab 5 on the 23rd of August. It's tab 5. If you go to page 55, his order supersedes the order of Mr. Justice Butcher, see paragraph 1, and then repeats it in paragraph 2. And then His Honour Judge Pelling, I'll come to him in due course, dealt with matter at hearing on the 29th of September. And the judgment, we don't have a judgment of Mr. Justice Bryan. I don't know why, but we don't. The only judgment we have for Mr. Justice Butcher is the one I'm going to show you in the note from Hogan Lovells. But we do have a reasoned judgment from His Honour Judge Pelling at tab 8 of this bundle.
Yes, we've read the pattern, Judge Pelling's judgment.
I'm very grateful. Now, can I, before I go into the factual position, can I show your lordships if you've got the authorities bundle? You have
Sorry?
you should have an authorities,
Yes.
an agreed joint authorities bundle. Can I ask the court to take that up and to turn to tab 5, which is a Privy Council decision. I couldn't find a better report than this, I'm afraid, but we've got the judgment. Privy Council decision from 2012.
Yeah, this says that you can interpret an order by reference to the judgment.
It does. Can I just show your lordship the relevant passage from Lord Sumption, which you've obviously got well in mind. Paragraphs 12 and 13 are the core of it. The argument on the basis of for the proprietor was that the scope of the remission was determined by the Court of Appeal's order, page 79, paragraph 12. The order allowed, quote, the appeal against the award of damages, end quote, and remitted the award to the arbitrators to determine, quote, the issue of damages, end quote. The question was, what did that mean? In the absence of any words of limitation, it said that this unambiguously means the entire issue as to damages as formulated in the arbitrator's terms of reference. In the opinion of the board, this approach to the construction of a judicial order is mistaken. It is, of course, correct that the scope of a remission depends on the construction of the order to remit. But implicit in the proprietor's argument is a suggestion that the process of construing the order is to be carried out in two discrete stages, the first of which is concerned only with the meaning of the words, and the second with the resolution of any ambiguities which may emerge from the first. So you look at the words on the page, and then you ask yourself if there's any ambiguity, and then you worry about the ambiguity if you find it. The court's reasons, so it said, are relevant only at the second stage, and then only if an ambiguity has been found. But that's back to front. Lord Sumption goes on to say, the board is unable to accept these propositions because the construction of a judicial order, like that of any other legal instrument, is a single coherent process. It depends on what the language of the order would convey in the circumstances in which a court made it, so far as these circumstances were before the court and patent to the parties. The reasons for making the order, which are given by the court in its judgment, are an overt and authoritative statement of the circumstances which it regarded as relevant. They are therefore always, not may, always admissible to construe the order. In particular, the interpretation of an order may be critically affected by knowing what the court considered to be the issue which its order was supposed to resolve. It's generally unhelpful to look for an ambiguity. True linguistic ambiguities are comparatively rare, and so on. And that, those observations from the Privy Council, well, have been followed and applied, not very often, but they've been followed and applied by this court.
We read through 14, 15, 16.
Yes, it's up to...
I mean, this is your response to Mr. Fenwick's submission that the underlying judgment is completely irrelevant.
Irrelevant.
And you say that's not so, and it may be that Mr. Fenwick's position is refined or overstated in the skeleton. Have you discussed this with him at all?
I haven't discussed this with him, but your leadership's right. His position in his respondent's notice, yes, and in his skeleton argument, is that the arbitration agreements and the jurisdiction clauses are completely irrelevant. Yeah. And that...
Maybe because he says there's no ambiguity.
Well,
the judge thought it was all very clear as well.
Well, the judge did, but the judge, with respect to the learned judge, didn't ask himself the right questions for reasons we'll come to. But yes, that's right, your leadership's right. And you're also right to that the relevant extract from Lord Sumption, it does all go up to 16. Can I just show you very briefly this court? Like, there's a few cases on there are few cases on the question of what is the proper legal approach to a court order. There was one attempt at it. I can just show you very briefly in tab 7, where Mr. Edward Murray, sitting as a deputy High Court judge.
Susie wasn't cited.
Well, that's right, and the learned deputy judge also had the misfortune. If you look at the date of his judgment, page 95, which was May the 8th, he had the misfortune to be giving his judgment on the same day as this court was hearing argument in Re A, if you look at tab 6. So the Court of Appeals treatment of this issue, you see that that was heard on May the 8th, 2014, and judgment on June the 26th. The deputy judge, as he then was dealing with giving judgment on May the 8th. And your lordship's right, sans souci wasn't cited, and nor was Re A, obviously, because it was only being argued that day. So that was.
So do we get any benefit from?
Well, you don't. Not obviously the legal analysis obviously has to be read in the light of Re A and sans souci. So no, not really is the answer. But he does make the observation. He does it by reference essentially to the contractual West Bromwich and so on analysis of Lord Hoffman, which obviously isn't the right approach. But he does say that one's concerned with the intention of the court in making the order, which is obviously right. More important is this court's treatment of the issue in Re A at tab 6, where sans souci is cited. So this is this court's decision. Obviously, sans souci is a Privy Council decision, but yeah. So the as a matter of as it were binding authority, it's in Re A, which is the case that I suppose really matters. And in Lord Justice Patton's judgment, it's a very short passage towards the end of his judgment at page 92. So there was an issue as to whether the order that had been made, which referred to something called Form E with a capital E, actually meant Form E1. So paragraph 30, page 92, Lord Justice Patton. The only issue, therefore, in the second appeal is whether paragraph 2 of the order is to be interpreted as referring to a Form E1, even though in terms it specifies Form E. If not, then the judge was wrong to hold that the father was in contempt by reason of his failure to file a revised Form E1. Then he deals with some of the facts which I'll skip over. Next paragraph. By then, however, the time for complying with paragraph 2 of the order had expired, and the real question is what someone in the position of the father would reasonably have understood the order to mean at the time when it was made. That's why we have to go back, with respect to my learned friend, back to Mr. Justice Butcher. It's not some sort of archaeological dig. That's the start of the order that we are now centrally concerned with.
Well, as I understand sans souci, the first question is there an ambiguity? Is that right?
No. We have to no, my lady. That's not right. What was being suggested in sans souci?
You don't look for an ambiguity.
What was being suggested in sans souci? No, it's very important.
Yes.
So paragraph. If you go back to paragraph 12 of Lord Sumption, the proprietor's response was simple, perhaps too simple. What they were saying, see the words "it is said" in the middle of that paragraph.
Yes.
It is said, it was submitted, that this unambiguously means the entire issue as to damages is formulated. In the absence of ambiguity in the language, it should not
That's
be
wrong. Understood.
That's wrong.
My mistake.
That's wrong.
And on the facts in sans souci, the offending phrase was the issue of damages.
That's right.
And the Privy Council held that properly construed in context,
yes,
you would say, that did not cover whatever it was. The
That's right.
Recoverability of, or the assessment of gross future management fees.
That's right. That's right. Exactly. So what was being submitted by the proprietor there was, look at the words. Have they got a clear meaning?
Right, so you don't need ambiguity. Delete that. Got it?
If they've got a clear meaning, that's the end of it. If there's an ambiguity, then, and Lord Sumption rejects that submission, unable to accept those propositions. So I was in Lord Justice Patton at paragraph 31 and then 32. So he sets out the order in the middle of paragraph 31. And then on the facts, he goes on to conclude, this is at letter G, it was obvious in context that his order for revised Form E was a reference to Form E1. So the case was a simple one in the facts. It was absurd to suggest the judge's order was or could have been interpreted in any other way. In other words, it didn't mean what it said. The words on the page weren't right. That's not how the order was to be interpreted, because that would be absurd. And then he sets out the extract from Lord Sumption at paragraph 13 that we've just seen. Now, finally, there's just one other to set the legal context. So we've got sans souci, and we've got this court in REA which follows and applies it, we can essentially, with respect to the deputy judge in Fell, leave that to one side because he didn't have the benefit of REA. The only other authority I want to show you at this stage in order to set the legal framework, I do this as a first instance decision, but the reason I do this is it's in the context of injunctions. It's a very recent decision of Mr. Justice Richards, tab 40 at page 237. And if you look at page 238 at the first paragraph, it's an application that came on before the judge because of an injunction made by Mr. Justice Fault with a penal notice. The judge sets that out. The question, paragraph 3 of interpretation, is as to the extent of the phrase transactional documents which constitute those receivables. The parties' respective positions on the meaning of that phrase can only be understood in light of the background leading up to the making of the order. So that's what this was about. And if you skip on to page 243, paragraph 18, the key paragraphs are 18 through to 20. The learned judge applies the principles set out in paragraph 41 of Lord Justice Flo's judgment, as he then was, in Tan Petroleum, who in turn drew on Lord Clark's judgment in one of the Abdizov cases. I haven't, none of us have put these other cases into the bundle because the relevant bit is here. The sole question for the court is what the order means, so that issues as to whether it should have been granted, and if so, in what terms, are not relevant to construction. In considering the meaning of an order, granting an injunction, the terms in which it was made are to be restrictively construed. Obviously, that's applicable here. Such are the penal consequences of breach that the order must be clear and unequivocal and strictly construed before a party will be found to have broken the terms of the order and thus to be in contempt of court. Various cases cited. The words of the order are to be given their natural and ordinary meaning and are to be construed in their context, including their historical context and with regard to the object of the order, citing Lord Justice Mummery and Hadkinson. And then paragraph 1 of Lord Justice Flo's summary sets out a caution against using perceptions as to whether an order should have been granted and if so, in what terms lead to construction. Next sentence but one. Therefore, the question is simply what the order means. And then he highlights the context, and then he refers to Sans Souci at paragraph 20, a case involving construction of a court order that did not contain an injunction. So, my Lord and Lady, those are the that's the relevant legal context by which the court, those are the legal tools, if you like, for the court when coming to ask itself the central question in this case, which is what does the anti-suit injunction mean? Does it have a meaning such that my client's attempt to intervene in the public law proceedings in Italy put it in breach of that order or not? My submission is that it doesn't have the meaning capable of putting my client in breach of it by attempting to intervene in the Italian proceedings. And let me try to explain why. The anti-suit injunction was intended, and we'll see this is clear beyond peradventure, intended by the applicant and by the court to prevent circumvention of the arbitration and or jurisdiction clauses that formed the basis of their application for the injunction. But now, as my lady has already observed, my learned friend now suggests, quote, paragraph 55 of the skeleton, the terms of the arbitration and jurisdiction clauses have no bearing on the contempt application. That's just bad law. They then go on to say in the skeleton, paragraph 57, that the anti-suit injunction scope is not limited and shouldn't be interpreted as being limited to preventing the breach of the arbitration and jurisdiction clauses. But at the same time, they also say in paragraph 11 of their skeleton argument something slightly different and rather more close to the mark. The last sentence of paragraph 11 of my learned friend's skeleton, I don't know whether the court's taking these out of the bundles as one normally does, but if you haven't, they're in the supplementary bundle. No, they're not, they're in the core bundle. At tab 4, the last sentence of my learned friend's paragraph 11. This is dealing with whether it matters that my client is or isn't the claimant in the Italian proceedings. They go on to say, last sentence, this would flout the ASI, which was to ensure that such disputes should be determined in the agreed forum. The question that underpins that is what's meant by such disputes. That's really critical, the issues and the disputes. It's certainly true that the jurisdiction and arbitration agreements are obviously concerned to ensure that matters falling within their proper scope are dealt with in the proper place. That's obviously right. And learned friend says that, well, it's no answer for us to say that an order once made shouldn't be complied with. He makes the point an order's got to be complied with, even if it's shown to be wrong. He's obviously right about that. I'm not suggesting to the contrary. But the anterior question is, what does the order mean? What's its proper scope? And my learned friends are seeking a construction of the anti-suit injunction now that's got no relation to the scope of the arbitration and jurisdiction clauses which gave birth to it, and gives the anti-suit injunction a scope which couldn't properly have founded an application for the order in the first place. Now we'll see that if we look at the way that Mr. Justice Butcher came to his conclusion. But before I come to that, can I just very quickly highlight some of the critical facts? The court may well have all this on board, in which case I'd be happy to be given the hurry up and move on. But the court will know, perhaps by now, I'm sure, that the relevant contracts arise out of something called the Kingisepp 2 project. It was the second of 2 projects. And what happened was that the claimant, the other side, entered into agreements for the design and construction of the plant. It entered into 3 contracts with my clients. The details don't really matter, but there was an offshore contract, an onshore contract, and a coordination agreement. Those are in the bundles, but we don't need to go to those unless the court wants. Article 6 of the offshore contract and the onshore contract required my clients to provide the claimant with various bonds. This case is concerned with 6 bonds, which have been issued respectively by the French and Italian banks. Again, the details don't matter, but there are 4 bonds issued by SocGen in Paris, and there's 1 advance payment bond issued by SocGen in Milan, and 1 performance bond issued by ING Bank in Milan. The bonds are all in materially the same form. They're on-demand bonds, so in other words, demands made by the claimant are agreed to be conclusive evidence of the sums due in paper. That's obviously the whole point. All of the bonds are subject to the exclusive jurisdiction of the courts of England and Wales. And these bonds are in the bundle. Just let me show you one of those jurisdiction clauses as an example. If you take the core bundle, you'll see the bonds are at tab 14 and following. If you turn to tab 15, page 133, this is just an example. You should be looking. I'm sorry, Lord.
The core bundle.
The core bundle, Lord. That's right.
Yeah.
We've got all of these bonds are in the core bundle. If you go to tab 15, page 133, if you look just a little down the page, you see governing law.
Yes.
Governed by and construed in accordance with the laws of England and Wales, each party irrevocably submits to the exclusive jurisdiction of the courts in England and Wales with regard to all matters arising from or in connection with this bond, and agrees that a judgment on any proceedings brought in the courts, etc., shall be conclusive. So that's the jurisdiction clause, and the same formulation is to be found in each of the 6 bonds. So my clients aren't, of course, party to the bonds, but under their contracts, they were required to provide the claimant with these on-demand bonds. The contracts to which my client is a party with the respondent provide for disputes to be resolved by arbitration under the ICC rules seated in London. Can I just show you where these are? in that same core bundle, tab 12, this is the offshore agreement. And if you turn, please, to page 98 of the bundle, you should be looking at clause 21.3.1. Any dispute with a capital D arising between owner with capital O and contractor in relation to this contract or in any way associated therewith, which is not settled amicably in accordance with clause 21.1, may be submitted by either party for binding resolution by arbitration. And then you see under the ICC, 3 rules, 3 arbitrators. And then the next subclause is place of arbitration to be London, English language seat shall be London, and so on. The onshore contract in the next tab is got.
We don't have the definition clause. Do we know what the definition of dispute with a capital D is?
We don't, but we can find we can get that for the court.
And can I ask a very stupid question? It says may be submitted for arbitration by
Yes.
either party, but it's not in dispute that this effectively stops anybody from litigating outside the arbitration clause, is it?
Well, it's certainly not in dispute that this clause has been acted upon and the arbitration has started. So whatever the potential conceivable wriggle room there might be in those words, it's no longer apposite if there is any. We'll
So under the Arbitration Act, you would normally expect to get a stay of proceedings automatically.
Yes. We'll dig out the definition of dispute. So the onshore clause is in the same terms, paragraph the same clause 21.3.1. There's one slight nuance, which is that the other contract, the third contract, the coordination and interface agreement, which is at tab 11, has got its arbitration provisions at 7.5.1, and there is a suggestion somewhere that there was an agreement that this arbitration agreement would, as it were, cover all 3 contracts. The details don't matter, but it's in slightly different.
Which page are you on now?
Page 88, my lord.
In the same bundle.
Same bundle, the third contract, but it's in materially the same terms.
Yeah.
So for the bonds, we've got one single jurisdiction clause. For the contracts, we've got 2 slightly different arbitration provisions, but the details don't matter.
Right.
Now, the bonds, as the court knows, have been called on by the respondent. And their position is that my clients were in repudiatory breach of their obligations under the contracts for the delivery of the project. So there are disputes between these parties, between my client and another defence client, about, for amongst other things, whether my clients were entitled to extensions of time or additional payments because of the COVID pandemic, whether we were entitled to suspend our services as a result of the export restrictions and financial sanctions imposed by the EU, whether they were entitled to terminate the contracts and on what grounds. The banks have rejected the call for demand on the bonds, primarily on the basis of the sanctions regime. My then friends' clients have commenced proceedings in the commercial court in London against the banks, and my client has become a party to those proceedings. And my client started arbitration against the respondent in London. And so both the jurisdiction clauses and the arbitration clauses have been, as it were, acted upon in different ways. Now, the question of the sanctions arises in this way. In the bonds proceedings, one question is whether the Eurochem entity, Eurochem NW, the claimant in those proceedings, is able to be paid or is able to call on those bonds, or both, or not, because of the sanctions regime. I don't know how much of the sanctions regime the courts had experience of, but in very broad terms, if take the example of Mr. Abramovich in Chelsea. It's the best way of explaining it. When a designated person is designated, Mr. Abramovich was last year, his assets are frozen, and it becomes unlawful to accept any payment, to make any payment to or on behalf of the designated person. But the freezing regime also bites immediately on any assets which are owned, held, or controlled by the designated person. That's why when Mr. Abramovich was sanctioned, it was illegal to buy a ticket to go and watch Chelsea. As soon as the asset is no longer owned by the designated person, of course, it's then freed from the sanctions regime, but the designated person remains designated. Here, Eurochem, the Eurochem group, was a group, I don't know whether it's common ground that it was a group which was under the control of Mr. Melnichenko, but that's certainly our case, prior to the sanctions regime. At some point, Mr. Melnichenko undertook some steps which transferred interests which he had previously held to his wife, Mrs. Melnichenko. Mr. Melnichenko has been designated both in the EU and the UK. Mr. Melnichenko has been designated in the EU. Yes, I was right the first time, I'm sorry. Mr. Melnichenko has been designated both under the UK regime and the EU regime. Mrs. Melnichenko has been designated only under the EU regime, in her own right. So this question, this public law question of whether particular legal persons in the Eurochem group are owned, held, or controlled by a designated person has arisen in relation to different legal persons in different jurisdictions. And different conclusions have been reached.
When you say different legal persons, are you talking about Mr. and Mrs. Melnichenko
No.
or different companies?
Different companies.
But it's common ground, isn't it, that they're all part of the same group, with ultimate control in somebody?
Well, yes, that's true. That's true. But against that apparent common factual background, different regulators in different countries have come to diametrically opposed conclusions as to whether the particular Eurochem entity which falls within their jurisdiction is or is not controlled by a designated person.
Why does that matter?
Well, that's perhaps a rather good question, but it matters to the parties. We know that it matters to these parties because Eurochem is trying to, what they're doing in Italy, this isn't a criticism, it's just an observation. The Italian authorities have concluded that the Italian entity is owned, held, or controlled.
And whether there are different regulators or not, and I'm sorry to interrupt, but you rely on that in your defence in the bank proceedings. So whether it's everybody is relying on whatever they can get.
Well, but
so it's not irrelevant that a different regulator under a different regime reaches a certain conclusion.
Both sides have pointed to, if you like, relying on the decisions which, as it were, appear to support their case. So, for example, the Swiss, the Germans, and the Belgians came to the opposite conclusion. In other words, concluded that the entities they were concerned with are not owned, held, or controlled by designated persons. But none of those, it's not suggested, certainly not by me, I don't think by my learned friend, it's certainly not suggested that the decision of, say, the Swiss entity, Swiss regulator in my learned friend's client's favour, or the Italian conclusion, which apparently supports my case, is in any way binding or determinative or gives rise to any kind of estoppel in the proceedings in London about whether...
What is the question in the London proceedings?
The question is whether the bonds are payable.
Yes, but is that a matter of the UK sanctions regime or the French and Italian sanctions regime? Is it a question of the regime applicable in London or applicable in the place of incorporation of the banks who are defendants?
Well, I think at the very least it must include the European sanctions regime.
We don't have the pleadings in the commercial court, actually.
Yes, we do.
I think we've got some of them, yes.
Supplementary bundle A, I think
Yes.
we've got some pleadings.
Tab 1.
So we've got the particulars of claim.
And your defence at tab 4.
That's right. That's right. And so,
Your contention is payment can't be ordered because of UK sanctions and would be illegal because of EU sanctions.
yes, and
So
so,
you're relying on both.
yes. And so, for example, at page 27, tab 4, paragraph 20.
27.
Page 27, my lord, paragraph 22. Mrs. Melnichenko was designated by the EU, and that's the
Whatever you
reason for it. And then over the page, paragraph 24, there's the Italian Financial Security Committee. That's the equivalent of OFSE, the Office of Sanctions, part of HM Treasury. And then paragraph 25, those are the points going the other way. The non-public and non-binding views expressed by some other EU regulators do not prevent the operation of or certain transaction involving, not determinative nor binding. And that's obviously right. These are just being prayed in aid as supporting mood music for the issue which arises in these proceedings. Not suggested that what the Italian regulator says, or what the Swiss regulator says, or the German regulator says, somehow inhibits this court from reaching the conclusions which are necessary in order to determine those cases. So, can I then take your lordship?
And why are you so keen to intervene in the Italian proceedings?
Well, Lord, because my clients take the view that they want to uphold the decision of the Italian regulator. For whatever reason, they're entitled, just as in a public law
Well, not
case.
for whatever reason, for the obvious reason.
Well, to protect their.
Intervene that you're interested because of the arbitration and the proceedings in England.
Because of these points that I've just shown you, because in the English proceedings, in particular the bond proceedings in which the defendants are the banks, but also in the arbitration, both sides are praying in aid, whether it gets them very far to pray them in aid is another matter, but both sides pray in aid the regulatory decisions across the US and the EU, which are, as it were, apparently helpful to them. And my learned friends' clients...
But your clients aren't seeking to uphold the Italian public law decree out of a fondness for Italian public law. They're doing it to improve their position in the underlying litigation stroke arbitration.
Well, they take the view that it would be, as it were, better rather than worse for them if the decree remained. That's right. Yes, that's right. So, and presumably the reason that the decree is being challenged is because the Italian entity obviously is subject to the freezing order and wants to be free of it in the same way as Eurochem subsidiaries in Germany, Belgium, and the UK aren't. That's right. I accept that. I accept that my client's intervention in the Italian proceedings is something which they're not doing it out of the goodness of their heart. They're doing it because they see their commercial interests as being consistent with them. But that's a completely different question from whether what they're doing there is undermining this court, the English court anti-suit injunction, which is designed to protect and maintain the integrity of the arbitration and jurisdiction clauses which underpin it. And so, we'll come to this shortly, but the court has to ask itself, well, how is the attempt to intervene in the Italian proceedings contrary to the anti-suit injunction? How is it contrary to the arbitration and jurisdiction agreement, What's wrong with it? Why is it inimical to the agreements that the parties are a party to? In my submission, it's not inimical to any of the agreements.
Well, that's the key point. On your analysis of the authorities, that's the key point.
Absolutely, and it's in many ways it's the key point, and in some ways it's the only point. It's the key point. And so I accept that the other side don't like the fact that we are intervening. Your Lordship might well say, underlying your Lordship's question was, well, if the Italian regulators made a decision, which it obviously, well, presumably took advisedly, it can be left to defend itself. Mr. Fenwick makes that point in his skeleton argument. Well, maybe he's right, maybe he's wrong about that. But for better or worse, my clients would like to intervene in those proceedings. So that's why we're here. And the question is, are we allowed to do that? And the answer is no, you can't because of the anti-suit injunction. And we say, well, no, because the anti-suit injunction doesn't have that scope. And if we're right about that, then whatever merits or otherwise there might be in our intervention, it's not something which concerns this court and certainly doesn't put us in contempt. But whether it gets us anywhere in Italy, and whether the answer in Italy, whatever it is, gets either party anywhere in the bonds proceedings or in the arbitration, who knows? But those are all matters for the day after tomorrow. So, Lord, can I take you now to the, as briefly as I can, to the documents which you've allowed in, the Hogan Lovells note. Now, I think you've got this, and my lady said electronically. I think Lord Justice Nugee didn't.
Yes.
Can I hand your Lordship this bundle? The page numbers will be different, but I'm going to do it by paragraph numbering, so if your Lordship will forgive me. Does my Lord Justice Lewison have the...
Well, I've got a bundle which my clerk printed out for me. It's got 7 documents in it.
Yes.
It starts with an application notice, then it's got a skeleton argument for the ex parte hearing.
Tab 3, my Lord. That's it. That's what I've just handed to Lord Justice Nugee. Would you turn to tab 3, my Lord, please?
Tab 3.
Tab 3.
That's the trust.
If there's a spare copy, that will be
Yes,
very
well, that would be even. Then we're all working.
Thank you very much.
Then we're all working for the same.
Thank you, that's very kind.
We'll speed things up.
Right, this is Hogan Lovells' note of the hearing.
That's right.
Of the hearing.
Yeah. Yes. So Hogan Lovells obviously were the applicant solicitors attending an ex parte hearing and in the usual way taking a note. Now, and obviously when we got to this stage, the court had the skeleton argument, which is at the tab before. I'm going to come to very briefly in a minute, but I want to focus on Hogan Lovells' note. So would you turn, please, to numbered page 39. Mr. Jory QC and my then friend Mr. MacDonald. At paragraph 1.51, counsel said, so the question really boils down to, if I can take you to our skeleton. So there's the words of the jurisdiction clause. This, of course, is a contract to which the defendants are not party. However, they are party to the coordination agreement, which, as I've already explained, provided for the bonds to be procured with this exclusive jurisdiction. So to the extent they've agreed the bonds will be subject to the jurisdiction and then procured the bonds, we start by saying that the jurisdiction on any issues under the bonds was something they knew and agreed would be exclusive to England. And then the learned judge, BJ is the shorthand for Mr. Justice Butcher, I'm afraid, the way you put that point is to say, if one can formulate a cause of action which the defendants could rely on to restrain the payment, it will have to be a cause of action which is effectively framed in the terms of the bonds. Absolutely, my lord. And then counsel went on to deal with some authorities. And then over the page, at 1.56, the judge asked, why does jurisdiction come into it? And the explanation is, what we say is they signed up to the coordination agreement saying, here are the bonds. And then he says, we asked to proceed on the basis, next but one paragraph, this exclusive jurisdiction clause should govern the arrangement. If we're wrong about that, it's certainly the position, if they're going to complain that breaches have been made by us, that we breached those contracts by purporting to terminate, which which appears consistent with their letter, then all those disputes are governed by an arbitration clause with a seat in London. So the argument was that it's the jurisdiction clauses that they were seeking to uphold, and that's really the focus of it. The judge then says, I understand that, but I'm still having trouble. I want to understand further. These bonds are entered into in a contract to which the defendants are not party. So the judge is trying to explore with them how do the jurisdiction clauses found an anti-suit injunction against my client. He says, the judge says, so how do you say that this exclusive jurisdiction clause should apply to them? Because you've not shown this court that the remedy they would be likely to pursue is equitable fraud. That's one way of attacking an on-demand bond, as I'm sure the court knows, which depends on a direct relationship between defendant and claimant. And so then there's more discussion about that.
Mr. McLean, you helpfully took us to a number of authorities. One of them, the last one, I think, referred to the SDI Retail Services case, where this court said that going through submissions
Yes.
is a very dangerous approach.
Yes.
And
Well,
is it safer for us to look at the actual note
well,
of the judgment, or is this helpful?
It probably. I was only going
I'm
to.
not going to stop you. I just like your comment on that.
Well, I understand the observation, which I think was a split observation. I think Mr. Justice Richards observed that one of the judges in the Court of Appeal took a different view.
Lord Justice Underhill took a different view, but
Yes.
Lord Justice Phillips, with whom Lord Justice Baker agreed,
Yes.
said that the submissions weren't really very helpful.
Yes, well, I don't know the context of that particular case, but this is an ex parte application, which, in my submission, does give it some further more import, as it were, because this must be the basis on which the judge then proceeds, because this is the only, there isn't any other side. But I'm happy to move to the, I'm happy to jump over this thing and go to the reasons of Mr. Justice Butcher. All I'm really seeking to show you is that I'm not so much focusing on the submission. The reason for showing you this is I'm interested, and in my submission, the court may well be interested in what we can see from the argument is how the judge's mind was working, which helps to inform the judgment which we're about to see. You can see from the questions.
Judges say a lot of things in argument, exploring, testing, putting points.
Well,
I don't think you can pay much attention to what judges say.
Well, I'll move on, but if one looks at the interventions of Mr. Justice Butcher, we will see that they are consistent with and underpin and inform the reasons which he then gives for allowing the application. But let me take you to the reasons of Mr. Justice Butcher.
Yeah. Starts on
Page 50. Yeah. That's right. And right at the beginning, 3.1, the claimant makes an application for an interim anti-suit injunction against the defendant, which it says is based, I think that should be on, an exclusive jurisdiction clause and an arbitration agreement in underlying bonds and contracts. And so that was the basis. That's what they were trying to do. And he then sets out
Is it controversial that the purpose of the anti-suit injunction was to protect the integrity of the London arbitration and exclusive jurisdiction clauses?
Well, I don't know. It seems to be now suggested that it's irrelevant.
Well, that's one point. But if that's wrong and it is relevant, then is it controversial that the purpose of the anti-suit injunction was essentially to protect the integrity of the exclusion?
That's really a question for my learned friend, really, but it certainly shouldn't be. It's obvious. And the next step in the argument then is if that's what the application is doing, and that's what it's about, then to take Lord Sumption's words again in San Sushi, the reasons for making the order are an overt and authoritative statement of the circumstances which are regarded as relevant, and then an order may be critically affected by knowing what the court considered to be the issue which its order was supposed to resolve. So the issue which Mr. Justice Butcher was resolving or dealing with is the question of the protection of the arbitration and jurisdiction clauses. And so then the learned judge goes on to, he deals with the facts, sets them out, and then at paragraph, at paragraph 3.6, the bonds are on-demand bonds. He sets them out, and sorry, forgive me. Yes,
Maybe
forgive me.
Put you off.
Forgive me. Forgive me. I turned over too many pages. Forgive me. Paragraph 3.1 of the judgment is the basis of the injunction. Then he sets out the facts, and then at 3.3, page 51 of the bundle, it is for that reason that the claimant brought its present application for an anti-suit injunction. It should be noted that 2 bonds were provided by Russian banks. They're not relevant. And so then that's the basis of the application. And then at 3.5, he sets out the bonds. And then he sets out the law at 3.11 through to 3.12, which he's taken from the skeleton argument that I was, that's in the previous tab. And I think I better to take it from the judgment, but for your note, in tab 2 of the skeleton argument, you'll see the skeleton argument for Mr. Justice Butcher set out the principles. It's page 15 through to 16 of this same bundle. And then, having done that, he says, at paragraph 330, the defendants were not party to the contracts contained in the bonds. Nevertheless, while I've only had one side of the argument, I am satisfied there's a high degree of probability that there's an applicable agreement on the basis either the exclusive jurisdiction clause under the bonds or that the arbitration agreements under the contract may apply. As to the first, if it's right the defendant is not a party to the bonds, which obviously it is, the case which they would appear to have to assert is. So now he's contemplating, what he's asking himself now is, what's the apprehended, what's it they fear, what's the concern about what these foreign proceedings might be? That there was a fraud on the part of the claimant says, which arises out of the bonds. The proof of the pudding in the middle of the paragraph on that is that the claimant, as well as the banks, would have to be a party to any claim brought by the defendant to restrain payment under the bonds. And if that was done somewhere else, that would not accord with the exclusive jurisdiction clauses in the bond, which specifically require all disputes or claims will be subject to exclusive jurisdiction of the English courts. Now, what had happened in relation to the first project, the other anterior project, was that my clients had made an application in Italy to prevent the bonds being paid. And that an order was made in their favour initially, and that was then overturned. And that was the catalyst for this application. And that's the concern, that something would happen somewhere else where an attempt would be made to prevent the bonds being paid out, and that would have to include the banks being a party. And then, as an alternative, if the exclusive jurisdiction clause under the bonds does not bite, that would presumably be because a dispute would arise out of the contracts, not the bonds, in which case the arbitration agreements would apply. Now, I'm going to come to this at the end of the submission, but the question before the Italian authorities before the Lazio Public Law Court, which is whether the Italian entity within the Eurochem group is or is not owned, held or controlled by Mrs. Melnichenko, doesn't arise out of the contracts between my client and the other side. It's got nothing to do with those contracts. It is, I accept, an issue between, or an issue involving that authority and a particular legal person in Italy, which is a very similar, perhaps, well, it's a very similar question, because of course, depending on the particular arrangements that are made with a particular legal person as to who takes over seats on boards and so on, just because they're all part of the same group doesn't necessarily lead to the conclusion that you get the same answer. It all depends on the facts. But a similar question in relation to a different legal person arises in relation to the bonds proceedings. But the issue before the Lazio Tribunal Court doesn't arise out of the contracts, and the decree which is being assailed by the Italian entity, which is subject to it, couldn't conceivably be dealt with by the arbitrators, and of course the Italian entity isn't a party to any relevant contract with an arbitration agreement in it. And if you then, the last paragraph that matters in the judgment is this one.
I thought, sorry, the point of detail, Eurochem Agro is another Russian company, isn't it? It's not an Italian company.
Is it not? It's Italian. Yes, it's Italian. I thought it's Italian, not Russian. It's Italian. Vigorous nodding from behind. I understood it to be Italian. I'm not sure.
It's an Italian company, milady. As a subsidiary under the single group of companies which.
Thank you.
Yeah, I thought it was.
It all goes back to first line trust.
Yes, that's right. At 314, the claimant says the arbitration agreement would not prevent their application from coming before the courts. The claimant accepted that my client could apply for an injunction to restrain payments. But
what is their application in 314?
For the injunction, I think.
The application for the injunction?
Yes, I think so.
Because the clauses you showed us waived the right to apply to the court except for conservatory measures.
Yes, and it was accepted by Milan and Friends clients in their skeleton that the arbitration agreement didn't shut out a party to that agreement in all and every circumstance from being able to make an application to another court. There was authority cited as to the four corners of that. But yes, that's right.
But when it says, I'm sorry, I'm being very slow. When it says would not prevent their application, does it mean the claimant's application for the anti-suit injunction, or does it mean the defendant's application for an injunction to restrain payment? I think it's the latter. I think it's the latter. If we go back to 313. 313 is considering the defendants making some sort of application in relation to the bond.
Yes, I think my lord is right.
I think
page 54, the judge says, as such, the claimant accepts the defendant.
Yes, I think my lord is right. I think that's right. And the decision of Mr. Justice Blair in the U&M case, which had been cited in the argument before him, is all about, if you look back to page 42, the U&M case, which was the extent to which it was possible to make an application somewhere else, notwithstanding the arbitration agreement. So the issue before Mr. Justice Blair in that case was about the ability to make application somewhere else and whether or not you were outflanking the arbitration agreement by doing something somewhere else. So if you look at page 43, the submission, I'm sorry to go back to the submission, but just to see if you understand the point. The natural, what was being submitted to Mr. Justice Butcher, page 43, the natural place, and therefore the presumption, is that it should be where the arbitration will be, unless, firstly and exceptionally, it can be held somewhere else if it needs to be for practical reasons, and secondly, it's not an attempt to outflank. Those are the two restrictions on the ability to do it anywhere else. So they accepted that it was conceptually possible for the other party, the counterparty to the arbitration agreement, to make an application, as it were, somewhere else. And that, I think, is what Mr. Justice Butcher is then considering in 314. Nothing in this clause shall preclude either party from taking provisional or conservatory measures. And although those would normally be measures at the seat of the arbitration, like Section 44 of the Arbitration Act, Mr. Justice Blair's case considered that there might be practical reasons why that wasn't possible and one have to go to some other court or tribunal. So that's what Mr. Justice Butcher is doing there. And indeed he then cites Mr. Justice Blair. Mr. Justice Morrison accepted is correct. The natural court for the granting of interim injunctive must be the country of the court and seat of arbitration. And very good reason to exercise its jurisdiction under Section 44. So, what we get out of this, in my submission, is that Mr. Justice Butcher was concerned, presented with an application which was concerned to protect the arbitration and jurisdiction clauses. And the order was intended and tailored to do that. And he made the order in the form, in the terms that he was asked to make it, for that purpose.
Is there any discussion of the extension beyond restraining to otherwise impairing?
I haven't. We were in the argument in the Hogan Lovells note, which we then took. I think went to the reasons. I haven't found any discussion in the skeleton or in the argument as recorded in Hogan Lovells note, which deals with that point, which was a point which the learned judge below made something of. In my submission, the judge made the order in the terms that he was asked to make it, for the purpose that he was asked to make it. What was that purpose? You've got my submission on that. Therefore, the order needs to be construed in that context, in that way, in that light.
I mean, the order was superseded by Mr. Justice Bryan's order.
Well, it was, but it's still in the same terms.
Yes.
But that's true. That's true. I mean,
and it was made in those terms by Mr. Justice Bryan, and in those terms by His Honour Judge Pelling.
That's true. Yes. Yes.
Which was the one that you broke?
I'm sorry.
Which order did you break?
Well, we didn't break any of them.
Which one are you? Have you been held to have broken?
Well, the one that was extant when we made our application to intervene, which is His Honour Judge Pelling's order.
That's what I thought.
But I accept that, obviously. But all I'm trying to do is to, rather than start before Mr. Justice Henshaw, there was some.
You're trying to go back.
Well, there was a lot of focus on His Honour Judge Pelling's judgment there.
Just look for a
Which I'm
moment
coming to.
at page 54 of this bundle.
Yes.
As you've shown us, the claimant submitted that the defendant, that is your clients, might argue that it could bring some sort of application before the French and Italian courts and drew attention to UNM.
Yes.
And the judge says, I consider that the concerns raised by reference to UNM can be dealt with in full on the return date.
And
that's Mr. Justice Bryan.
Well, actually, it's His Honour Judge Pelling who deals with it. I'm coming to that in just a moment. But His Honour Judge Pelling, in the end, deals with it.
Well, you were making some point about Mr. Justice Butcher making the order in the terms in which he was asked to do. But he's doing it on an interim, without notice basis, contemplating that the precise width of the order is going to be the subject of discussion at the return date.
Yes, but
so what's the point?
Well, the point is that the purpose, the problem which Mr. Justice Butcher is dealing with is the problem of the applicant coming to him saying, we've got these jurisdiction and arbitration agreements, which we want to have protected.
That's what anti-suit injunctions are for.
Yes, that's right.
That's their basis.
Yes, but if they had come to court and said that there was no apprehension of the proceeding, but we'll see in his own Judge Pelling's judgment in a minute what he was concerned with, that my clients were going to take or were contemplating taking steps in France and or Italy to deal specifically on the bonds. If we leave that to one side for a moment and contemplate a situation where we've got the same contracts, the same jurisdiction clauses, the same arbitration agreements, and the only question the only reason advanced to a court, Mr. Justice Butcher or Mr. Justice Bryan or His Honour Judge Pelling, is an apprehension that because of the sanctions regime, assume that all the sanctions applied then as they apply now. And the applicants came to court and said, there might be a dust-up in the public law court in Italy about one of the companies to which we belong. We anticipate that our subsidiary will want to challenge any such decision. In principle, subject to the permission of the Italian court, others can intervene in those proceedings if permission is given. We want to stop Tecnimont doing that. Can we have an anti-suit injunction in relation to it? Yeah. And the answer would be, in my submission, no, you can't. Why not? Well, because it doesn't fall within any of the categories of protecting the arbitration agreement, the jurisdiction agreement. It doesn't give rise to a quasi-contractual claim. None of those. What's happened here is that an order which was obtained to address the problem that Mr. Justice Butcher and Mr. Justice Bryan and His Honour Judge Pelling are grappling with is now being used in a quite different way from the way in which it was intended, not only by the claimants, that probably doesn't matter what they're entitled to bob and weave to suit their position. That's what happens in litigation. But it's being used in a way that was entirely contrary to the intention of the court in granting it. And of course, I accept, as I've already accepted, that if the order means what the order means, well, it has to be complied with. But it's not as simple as that.
But you say it's entirely contrary to the intention of the court, and that the Italian intervention would fall outside the relevant clauses. That's
Yes.
not what the judge found.
Well, but the judge was wrong.
The judge went on, didn't he? So he said, well, I don't think I'm going to get much help from looking at whether or not there's been a breach of these clauses. But if I need to, I consider there has been.
Yes, well, I'm going to come to Mr. Justice Henshaw as shortly. I just want to deal with Mr. Justice Bryan and His Honour Judge Pelling first. But yes, that's right. I accept that Mr. Justice Henshaw came to that conclusion. He came to various conclusions, one or two of which were inconsistent with the conclusion of Mr. Justice Pelling, His Honour Judge Pelling, who, as we'll see in a minute, concluded that the basis for the anti-suit injunction was the arbitration provision, which isn't what Mr. Justice Henshaw ranged rather more widely than that. And he also, in particular, and I am going to deal with this, but he also, in particular, the judge, found that where's the judgment gone? Lost the judgment. The judge at paragraph 43.
Which judge are you talking about now?
Mr. Justice Henshaw.
Henshaw.
I'm going to come to this, but since my lady raises it, I'll just sum it up briefly. Now, so what the judge sets out the background, the background facts and the procedural background, and then he sets out the arbitration and jurisdiction clause. And then under heading analysis at page 72, he then sets out submissions on behalf of my clients. And he sets out the submissions at paragraphs 23 through to 27 And then over the page at 20, he doesn't accept them. And he says, this is all he says: I bear in mind the ASI is an order, endorser, a penal notice, and that I must look for its clear meaning. But I do consider the position to be clear. So that's his analysis of the order, question of law. And yes, and then he goes on to deal with the application to intervene, but he doesn't. There's no analysis really of why what's happened in Italy is within the scope of
That's not right. You were going to go to paragraph 43.
I
for
am.
example.
I am going to go.
And that's where there is exactly this analysis
yes,
in
but,
responding to the arguments that were made
on
behalf of your client.
Yes,
Paragraph 31
well,
is where he explains this is the injunction he thinks has been breached.
I'm sorry,
Involves
Lord.
the pursuit of proceedings for the purpose of otherwise impairing payments.
I'm sorry, Lord. Your
Paragraph 31.
paragraph 31 of Mr. Justice Henshaw.
That involves the pursuit of proceedings for the purpose of otherwise impairing payment under the bond. That's the bit of the injunction he thinks has been breached.
In paragraph
31, page 74.
In my view, that involves proceedings for the purpose of otherwise. Yes. Well, that's what he says.
Yeah.
But the application, he's misunderstood what's going on in the Italian proceedings. The Italian proceedings have got nothing to do with the bonds. The only relevance of the bonds is the point we discussed earlier about both sides relying on the public law authorities which help them or don't help them, as the case may be, across Europe. But that's not sufficient to be caught by the order. And that's because when we come to the question of under the heading mischief, which is how it was treated before the court below, he sets out the claim form and the relief at paragraph 37, and noting the point that my Lord Justice Nugee made, was there any discussion about why this particular wording was arrived at, to which my answer is, I haven't found any. My learned friend may have found some, but I haven't found any. And then over the page, it follows the court, paragraph 38 in the middle. The court was persuaded to grant relief in terms which were wider than the specific context. But the context, whatever the words were, the reason why the order was given and the purpose of the order was to protect the jurisdiction in arbitration agreements. That's what it was all about. And then we'll come. I'm going to come to it on Judge Pelling. So if the court doesn't mind, I'll leave 39 and 40 for the moment. And then at paragraph 43, the judge says this, and this is fundamental to my, as it were, assault on the judgment. The judge says this: it makes no difference in my view that the proceedings in Italy are a public law dispute, which only the Italian courts could resolve. Well, why not? He goes on to say the relevant point is this is an issue which arises part of the public law dispute whether Eurochem AG is or is not in fact controlled by sanctioned individuals. And it's that issue which Tecnimont, by its intervention in the Italian proceedings, wishes the Italian court to determine in its favour. That's obviously correct. That's inconsistent with Tecnimont's promise in the arbitration agreement to submit that dispute to arbitration. It didn't undertake to submit that dispute to arbitration. The arbitration is about disputes. We'll provide
right, so does your argument now turn on the meaning of dispute?
Well, it's dispute, but it's dispute between the owner and the contractor. That's what the arbitration agreement's about.
Yes.
What he says, 43 builds on 42. What he says in 42 is there is an issue between Tecnimont and the claimant, so between the two parties to the arbitration agreement.
Yes.
There is an issue as to whether Eurochem AG, i.e. not a party to that agreement but a parent, is or is not controlled by sanctioned individuals.
Yeah.
He's identified that as an issue which arises in your dispute, which is an arbitrable dispute. And what he says in 42 is that's part of what's caught by the arbitration agreement, that issue. And then he says in 43, that's the same issue you're trying to litigate in Italy. And it doesn't matter. Those are public law proceedings. It's the same issue. So the question is this. If in the arbitration an issue arises, is Eurochem AG controlled by sanctioned individuals? And that same issue is in the Italian proceedings, and you're trying to support the position in the Italian proceedings. Is that something that you're at liberty to do or not? And
Well,
he says no,
but
because it's the same issue.
But it's not the same issue.
No, it is. The issue is Eurochem AG controlled by sanctioned individuals? That's what he's identified as the issue.
Well,
And he says that issue arises in the arbitration, and that exact same issue arises in Italy.
well, the issue that arises is whether the particular entity in particular proceedings, part of the Eurochem group, is or isn't controlled by a designated individual.
Yes, that's the Eurochem Agro S.P.A, which is the Italian subsidiary. I understand that.
Yes.
But in order to decide that, you have to somebody has to persuade the Italian court as to whether its parent, Eurochem AG, is.
But the issue that arises, nothing that's happening in Italy or in potentially in Belgium or Germany or any other jurisdiction dealing with the regulation of sanctioned individuals, nothing that happens there is determining or interfering with or preventing or hindering the determination of the issues in the London proceedings by the arbitrators or the commercial court, respectively.
Well,
At the very
go on.
at the very most, what's happening in those other proceedings gives some evidential succor to submissions which are made in those proceedings. But what the applicants were concerned about was the subverting of the arbitration and jurisdiction clauses. That's why they went to court. That's why they went to Mr. Justice Butcher. And now the arbitration and the bond proceedings are underway in London and are continuing in the normal way, and no one is trying to interfere with them. And the learned judge goes on in this paragraph 43 to say, but we're in the middle of the part, that's inconsistent with Tecnimont's promise in the arbitration agreement to submit that dispute to arbitration. It's true, as Tecnimont points out, that issue will still remain to be determined by the arbitral tribunal. That's the point I've just made. But in my view, the arbitration agreement also entails that a party will not seek to litigate issues abroad as a preliminary to, or in order to deploy as evidence in, the arbitration agreement. Such proliferation of proceedings is inimical to Tecnimont's agreement to resolve disputes solely by means of arbitration in the agreed form. Now, if one contemplates that the Eurochem NW was an Italian entity, and it had been the subject of the Italian decree, and we've got these arbitration agreements in the same terms between the parties, could it be right that neither party could seek to overturn that decree without the consent of the other, because that would be in breach of the arbitration agreement? That would be a very curious result. But that, I think, is the logical conclusion of Miller and Friends' argument. It's a breach of the arbitration agreement, he says, for my clients to go to Italy. It's not a breach of Eurochem Agro to go to the Italian court because it's not party to the arbitration agreement. So that's a convenient way of avoiding the heads he wins and tails I lose argument. If you change the facts very slightly and test the argument, is it really right that where parties have got a commercial agreement about a project that they've got on, and something happens in public law terms in some other jurisdiction, that neither of them can go to court to defend their positions without the agreement of the other? In circumstances where those proceedings are not the sort of proceedings, not the sort of issue that could ever found an anti-suit injunction before the English court in the first place. So, with respect to Mr. Justice Henshaw, he doesn't give any further reasoning or authority or legal rationale for his conclusion that the arbitration agreement also entails that a party will not seek to litigate issues abroad as a preliminary to or in order to deploy evidence in the arbitration. He doesn't do that at all. And perhaps if I, for the moment, abandon my attempt to go to Mr. Justice, His Honour Judge Pellings to say, can I, just in order to deal with this paragraph 43 point, because it's clearly of some importance to the court, can I show you a couple of the authorities which my learned friends have helpfully put into the authorities bundle on the scope of arbitration clauses? Because it's the arbitration clause that matters here, not the jurisdiction agreement, for the reasons His Honour Judge Pelling gives. It's my learned friend's going to get home on the arbitration agreement or not at all. If he's wrong about that, he can't conceivably get home on the jurisdiction clause. But anyway, can I take you to the authorities bundle? And there are several authorities here on arbitration clauses. The first is Fiona Trust. The court, I'm sure, will be more than familiar with Fiona Trust, decision of the House of Lords and the relevant passage in Lord Hoffman's judgment. And unless you want me to, I wasn't going to.
Where are we going? Fiona Trust.
Fiona Trust, tab 3.
Yep.
The relevant paragraphs are 7 and 13. Well, perhaps it is just worth reminding ourselves of Lord Hoffman. It's the shorthand for Fiona Trust often is it's said to be it's one-stop shop. Actually I think it was Mr. Butcher, Queen's Counsel as he then was, who was arguing about what different words meant and so on. And the court the Court of Appeal originally, or Justice Longmore I think it was, had said the time had come to stop the angels dancing in the head of a pin. And Lord Hoffman says at paragraph 7, if one accepts this is the purpose of an arbitration clause, i.e. the purpose set out in the paragraph before, quick, efficient adjudication, its construction must be influenced by whether the parties as rational businessmen were likely to have intended only some of the questions arising out of their relationship were to be submitted to arbitration and others were to be decided by national courts. Could they have intended the question of whether the contract was repudiated should be decided by arbitration, but the question of whether it was induced by misrepresentation should be decided by a court? If, as appears to be generally accepted, there's no rational basis on which businessmen would be likely to wish to have questions of the validity and enforceability of the contract decided by one tribunal and questions about its performance decided by another, one would need to find very clear language before deciding that they must have had such an intention. And then you give effect so far as the language will permit to the commercial purpose. And then at paragraph 13, in my opinion, the construction of an arbitration clause should start from the assumption that the parties as rational businessmen are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. And Lord Hope said something similar at paragraph 26, at page 46. And if I can just invite you to look at the sentence that begins at E, it's the sentence beginning, but there is no conflict, if the court sees that. Between that proposition and the guidance which Lord Justice Longmore gave about the interpretation of jurisdiction and arbitration clauses, the proposition that any jurisdiction or arbitration clause in an international commercial contract should be liberally construed promotes legal certainty. It serves to underline the golden rule that if the parties wish to have issues as to the validity of their contract decided by one tribunal and issues as to its meaning or performance decided by another, they must say so expressly. Otherwise, it can be agreed on a single tribunal for the resolution of all such disputes. Now, there are two cases which I want to show you which also deal with this same topic. One is a case called River Rock Securities Limited, an international bank of St. Petersburg, which is at tab 9, the decision of Mr. Justice Foxton in the Commercial Court. And this case, we can pick up at page 136 of the one, paragraph 55, under the heading, do the claims advanced in the St. Petersburg action fall within the LCIE arbitration agreement's matter of construction? And the submission, paragraph 55, was that they didn't, as a matter of construction. And the learned judge says, subject to one point I deal with below, I can deal with this issue briefly. I agree with the conclusions expressed by Mr. Justice Mayles, as he then was in Norrie Holding, and in particular, the presumption that an arbitration agreement should not extend to claims which only arise on a company's insolvency is not part of English law. Then he refers to Fiona Trust. And then at 65, in the LCI arbitration, the bank had indicated its intention to counterclaim if jurisdiction was established. I'm sorry, just before I go to 60, I should take to 61 before I go to 65. Sorry.
Where are we going now?
61, I'm sorry, Maud. 61, page 138. He refers to Whelan's and the Michael Wilson case, and then says this: consistent with that principle, an anti-suit injunction may be granted, even if the effect of doing so is to prevent the respondent from invoking constitutional grounds of objection to the contract, which cannot be raised outside of the foreign jurisdiction. One of the advantages of agreeing both the forum and applicable law for any disputes is that the parties may avoid exposure to certain types of claim recognised by the home courts of one or other of them. And then at 65, the bank had indicated its intention to counterclaim on the basis that the transactions were fraudulent and void or should be set aside. In the separate proceedings, which the bank had also commenced, its claim had been advanced on the basis of a fraudulent conspiracy to defraud, which sought to set aside the termination payment, but didn't rely on any insolvency-related claims. I agree with Mr. Justice Mayles' analysis, which is consistent with the authorities considered above, and also with the principle. It's no bar to a stay or an anti-suit injunction that a particular cause of action or form of relief, which is available to a foreign court in a dispute, which is characterised by English law as contractual, as a matter of substance, will not be available in an arbitration with an English seat. So, the scope of the Fiona Trust analysis isn't unconstrained, and we see in the final case I want to show you in this extract, a decision of Patricia Robertson, sitting as a Deputy High Court judge in a case called Eastern Pacific at the next tab 10.
Sorry, what do you say that River Rock is authority for?
It's authority for the proposition that an anti-suit injunction can be granted in relation, in such a way that inhibits a party from, in a way where the party can't bring some claim, some remedy in the agreed jurisdiction, which it could have brought elsewhere. It's no use coming along and saying, I could have done this somewhere else. I can't do this. If we were somewhere, I could do this. The question is, well, you've agreed that all your contractual claims will be subject to the arbitration. You've made your bed, you've got to lie in it.
It's not, but I thought Fiona Trust wasn't limited to contractual claims. I thought it would extend to tortious claims.
Yes, of course. Yes, of course. It does, of course, extend to... Yes, but it's not... It doesn't... Fiona Trust is not to be interpreted so wide that any dispute between the parties about anything at all is within the scope of the arbitration.
So what does Mr. Justice Foxton mean in 61 when he says that the anti-suit injunction may be granted even if it prevents the respondent from invoking what he calls constitutional grounds of objection? What's he talking about with constitutional grounds of objection?
Well, that's the point. That's the point I've just been making to my Lord Justice Nugee. Constitutional grounds of objection to the contract, which cannot be raised outside of the foreign jurisdiction. So
you can stop that by an anti-suit injunction?
Yes, that's right. That's right.
Sorry, so how does that help you?
Well, what it shows is that it's really 65 I'm relying on, that the question for the court is whether the action that's been taken in the foreign jurisdiction is within the contemplation of the arbitration agreement. If what's happening in the foreign court would be categorised by English law as contractual as a matter of substance, then the fact that the foreign jurisdiction sees it as something else, doesn't matter, because clearly it falls within the scope of the arbitration agreement. Equally, to pick up on Lord Justice Nugee's point, if what's happening in the foreign proceedings is some sort of tort or other legal wrong which arises out of the commercial position of the parties, then Fiona Trust would tell us that's also going to be caught by the one-stop shop regime, obviously. And that's the concept of the width of the arbitration agreement. But here, we've got, I keep coming back to this point, we've got an issue in Italy which isn't...
You say the issue in Italy is not within the scope of the arbitration agreement.
It's got nothing to do with the claimant party in England. It's got nothing directly to do with the bonds. It may be that it's attacked by my client or seeking to support the decree because they perceive that to be in their commercial interest. But that doesn't matter. What the parties in their arbitration agreement have done is agree to submit disputes between the owner and the contractor arising out of or in any way connected with their relationship to arbitration. And what's happening in Italy has got nothing to do with that.
What do you say about what Mr. Justice Foxton says in 64 and 65? He quotes Mr. Justice Males, saying what matters is a substance rather than a form. In
Yes.
this case, the parties dispute a straightforward factual dispute,
Yes.
whether the August transactions constitute a fraud. And he says he agrees with that. So here, the factual dispute is the respondent, Eurochem North-West, a sanctioned company.
Well,
The reason that you say it's sanctioned is that ultimately it's under control of Mr. or Mrs. Yelenchenko.
well, that's with respect not
And
quite.
that's the same,
but it's
that's
not,
the same
but
issue.
With respect, it's not quite right, Lord, for this reason. And the same way to apply here. If one thinks about a decision by OFSI in the public law context, I don't know anything about Italian public law, but if we think about the position in English public law, the question is not likely, if the English admin court, if the Italian admin court takes the same approach as the English court does to public law, it will not, at least not necessarily, but not likely to be resolving the factual question of whether Eurochem Agro is or is not controlled by Mrs. Melnichenko. It's a public law question of whether the decree is a public law valid decree.
I'm not sure about that. Looking
Well-
at the documents in the Italian proceedings, but if you want to make that good, you better show us.
But and the same would apply in England. The decision of OFSI
Well, I
to designate
appreciate
somebody.
that in England, the administrative court would not decide disputed questions of fact. I
No.
appreciate that.
So, even if the Italian court was deciding disputed issues of fact between Eurochem Agro and the Italian authorities, which is what it would be doing, not between any Eurochem entity and my client, and even if it was deciding that, it wouldn't carry over and bind or in any way tie the hands of the English court. So the only place where a binding factual conclusion is going to be arrived at as to whether, for relevant purposes, Mr. and or Mrs. Melnichenko owned, hold, or control Eurochem NW is here in the arbitration and or in the bond proceedings. So, with respect, it's not right to say, well, what about the substance rather than the form? Isn't the substance? I mean, what's behind my Lord's question is, well, essentially, these are my words, not your Lordship's. What's really going on in Italy is that there's a challenge which is in substance a question which is the same question which is going to be resolved in England. And that's emphatically not right. It arises in a similar context, obviously, involves the same people, obviously, but it's a different question. And just very briefly, the final case on this trilogy I want to show you is over the page Eastern Pacific Chartering. And I show you this because it captures it nicely in my submission. Here, Eastern Pacific Chartering, the claimant chartered an internet time charter party with the defendant with a jurisdiction clause which provided that any dispute, quote, arising out of or in connection with the charter would be subject to the exclusive jurisdiction of the English court. Then there was a dispute about the balance of hire, and the claimant arrested ships in Gibraltar. While Gibraltar proceedings were ongoing, the defendant also started proceedings before the English court, which were then defended, and there were various counterclaims, including claims in tort for damages for the wrongful arrest of the vessel. So then there was an attempt to dismiss and strike out those claims on the basis that the English court had no jurisdiction and should decline jurisdiction in favour of Gibraltar. And the learned deputy judge held that a tort claim might be said to arise in connection with a charter, not only where there were parallel claims in tort and contract, or where there was a factual overlap or linkage between the tort and the contractual claims, but also where the claim arose solely in tort and was in a meaningful sense causatively connected with the relationship created by the charter and the rights and obligations arising therefrom. Not just similar to or in some way relevant as background for, but causatively connected. And the judge's analysis is at page 167, where she starts with paragraph 34 with Fiona Trust. And the head note reflects what she says in paragraph 37.
I mean, the phrase causatively connected was adopted by the judge there because it fitted the facts of the case. But you're not suggesting that that's a formal definition or requirement or anything like that?
No. But it's a useful way of testing whether the linkage, if there is one, between what's happening in some other place is sufficient to bring it within the scope of the arbitration agreement. And in some ways, the beginning and the middle and the end of the submission is the arbitration agreement itself, which you saw in clause 7.1 at tab 11. Any dispute arising between owner and one or more contractor. But there isn't a dispute between the owner and contractor about the sanctions treatment of the Italian subsidiary. Now, can I just fairly briefly, I just want to show you what His Honour Judge Pelling was confronted with and what he did with it. Can I then? So we're skipping over Mr. Justice Bryan, who continued the order as you've seen.
And there's no note of his judgment.
There's no note of his judgment. There's a skeleton argument that was submitted to him, in which, as before, the applicant said the issue was and remains where any proceedings by the contractors to restrain payment of the bonds should be brought. And they also said the claimant doesn't come to court to stifle argument, but to ensure that it's heard in the correct forum. I'll just show you that just very briefly. It's in that supplementary material that we handed up at tab 4. At paragraph, well, page 60. This is the skeleton before Mr. Justice Bryan. I'm not going to go into the arguments, the submissions here in any detail. Paragraph 2, the issue was where any proceedings to restrain payment of the bond should be brought.
Sorry, it's my fault. I don't have that document. Supplementary bundle B.
Your ladyship will have it electronically, I think.
This is in the clip that was handed up this morning.
Thank you.
Tab 4, page 60, my lady. This is the skeleton for the return date.
Thank you.
Paragraph 2. The issue before the court was and remains where any proceedings by the defendants to restrain payment of the bond should be brought. 5. The claimant does not come to court to stifle argument, but to ensure that it is heard in the correct forum. Now, the only place, the only forum to hear the public law issues that arise in relation to the Italian decree is in Lazio. obviously. But the claimants are seeking the stifle argument there. And yet they're doing so in a way which doesn't mean at all that the proceedings to restrain payment of the bonds, or the proceedings about the bonds, are brought in the wrong place. They're not. They've been brought in London. Those proceedings are now underway. So they are seeking precisely to do that which they disclaim in paragraph 5. They are seeking the stifle argument. But anyway, Mr. Justice Bryan continued the order, and then there was a further return date before His Honour Judge Pelling. And again, in the supplementary bundle, at page 61, this is the next skeleton argument before His Honour Judge Pelling. And paragraph 3, page 61, Eurochem was concerned that, so this is now the order which, to take Lord Justice Nugee's observation or question, this is the order that we are said to have breached. So coming to Mr. Justice, His Honour Judge Pelling. Eurochem was concerned that despite the English jurisdiction clauses, the contractors would institute proceedings in Italy and or France, seeking to restrain payment under the bonds. And then at paragraphs 43 through to 46,
Was the 23rd of August the hearing before Mr. Justice Bryan?
yes, that's right.
Right, so there was, he obviously did not have time to resolve the disputes.
I infer that's right. But I don't know. There's no. I asked if there was any note of a judgment and nil return, so I don't know. At paragraphs 43 to 46 is the law relating to anti-suit injunctions and interim relief. Quasi-contractual cases are then dealt with next. Interim relief in support of arbitration. And so the judge, in his judgment, which is at tab 8, there was an additional factor now which wasn't before Mr. Justice Bryan, and it's the one which Mr. Justice Butcher had said is a matter for the return date, the point Lord Justice Lewison made earlier. So His Honour Judge Pelling, paragraph 2, page 107. There are 3 issues. Whether the ASI should continue, and if so in what terms, or be discharged on the merits. There's a full and frank disclosure point. That needn't concern us. And then 3, assuming that the anti-suit injunction should continue on existing terms or should be re-granted on those terms, whether the defendant should nonetheless be permitted to commence proceedings in Italy or France to restrain banks in those jurisdictions honouring calls made on various on-demand bonds issued by those banks in favour of Eurochem, or requiring Eurochem to suspend its calls on the bonds. Now this is the application which Mr. Justice Butcher was concerned with in that paragraph 314. And the judge in paragraph 11 correctly identified that the court can grant an anti-suit injunction in 3 circumstances. 1, where there is between the claimant and defendant a jurisdiction agreement requiring the disputes to be submitted for determination by the courts of England and Wales. 2, an arbitration agreement. Or 3, where the respondent to the application for that ASI is founding a claim on rights arising from a contract which contains a relevant jurisdiction and arbitration agreement. That's a basis sometimes referred to as a quasi-contractual ground. Now clearly that doesn't apply here. I'm not sure my own friend suggested it does, actually, to be fair to him, but clearly that doesn't apply. And so at paragraph 13, the judge then found, as is obvious, and as Mr. Justice Butcher had been discussing with counsel at the ex parte application, it's common ground that the defendants were not parties to the contract contained in or evidenced by the bonds. It follows that the exclusive jurisdiction clause contained within the bond is binding contractually only between the banks and Eurochem, and thus does not form even an arguable basis for seeking an anti-suit injunction against the defendants, subject to the availability of the quasi-contractual basis, to which I return below to the extent that it's necessary to do so. Now, that observation is correct, and it's inconsistent with Mr. Justice Henshaw, who appeared to come to the conclusion that the jurisdiction clause was also relevant, as well as the arbitration agreement. But anyway,
he sort of said if relevant, he just didn't really feel he needed to because of the decision he reached on the arbitration clause.
Whatever it might be, His Honour Judge Pelling is correct in that analysis, and the quasi-contractual ground can't possibly apply to what's happening in Italy. My client's attempt to intervene in Italy doesn't arise from the bond contract. It arises from the fact that the sanctions regimes come in and apply to Eurochem. It certainly doesn't arise from the contract, from the bond contract, which contains a jurisdiction clause. So, so that can't be the basis of it. So at 23 and 24, paragraphs 23 and 24, so His Honour Judge Pelling here upholds the anti-suit injunction on the basis of the arbitration agreement, and doesn't in the end draw any conclusion, see paragraph 24, as to whether the anti-suit injunction could have been granted on a quasi-contractual basis. And that's because, in paragraph 23, in order to meet the point that if an injunction were to be sought restraining payment on the ground that payment was unlawful according to the laws of the place of performance, that issue could and should be resolved by the courts of England and Wales. The defendant submitted that although the regulations give rise to defence if a claim were to be made against the banks in either Italy or France, the law of Italy and France doesn't make it unlawful to make or satisfy a claim, so that the Raleigh-Bullis principle would not apply. It follows, so it is submitted, that for practical reasons, the defendant should be permitted to apply to courts of Italy or France, because the remedy they seek would not be granted by either the English courts applying English law, or presumably by an arbitral tribunal applying English law. This comes back to the observations that Mr. Justice Foxton was making about not being the mere fact that you can't get what you would be otherwise able to get in the absence of the arbitration agreement doesn't get you very far. In my judgment, this argument is entirely fallacious. If the defendants are correct, then the effect of permitting them to apply to the courts in Italy or France for relief that they could not obtain from the courts in England would be to permit the defendants to outflank the arbitration agreement that the parties have entered into. That is, that there should be an arbitration seated in London, which is subject to English law, and which by agreement must apply English law to resolve the disputes referred to the arbitral tribunal. So, to take half a step back and take stock, His Honour Judge Pelling upholds the anti-suit injunction on that basis, and on that basis alone, that the type of proceedings which my clients were contemplating taking, which he goes on to discuss in which he discusses here, would outflank the arbitration agreement. That's why they're not to be permitted. Because, as the judge says, what they would be doing would be applying somewhere else, in Italy or France, for some remedy that they know they couldn't get from the English courts applying English law. And that would be to outflank the arbitration agreement. And I don't have any problem with that analysis, which is clearly correct. But what happened in the sanctions regime, the sanctions context later in relation to the public law proceedings in Italy, doesn't outflank the arbitration agreement at all. It doesn't inhibit or prevent the arbitrators from doing anything. It doesn't take any issue in the arbitration off the table. It doesn't decide any issue between the parties that's before the arbitrator that could possibly give rise to an issue estoppel that would in any way inhibit either party to the arbitration from making any submission they might wish. And it doesn't outflank the arbitration in any shape, size, or form. And so it's not within the basis in which His Honour Judge Pelling upheld the injunction. It's impossible, in my submission, sensibly to construe the order as restraining my client from intervening in the Lazio proceedings. And when my learned friends say in the skeleton argument, paragraph 57, that it's clear from the wording of the anti-suit injunction that it wasn't intended to precisely reflect either the arbitration or jurisdiction clauses. This is the point about the wording being slightly different from the arbitration, from the clauses themselves. Well, we don't know why that wording was put before the court. We know it was accepted by the court. But what matters is that those orders, the purpose, the problem those orders were addressing was the apprehended interference with the arbitration and jurisdiction clauses. And that's, we see that from beginning to end in Mr. Justice Butcher's analysis and in the analysis of His Honour Judge Pelling. So, if I can...
But, I mean, one of the things the arbitrator and or the English court will have to decide is whether it is unlawful to pay out under the bonds.
Yes, that's right.
And Eurochem will no doubt put some pieces of evidence into the scale, and you will put some other pieces of evidence into the scale on the other side and see which way the balance ultimately tips. And one of the pieces of evidence you want to put into the scale is the Italian decree. Right so far?
Well, yes, save that the question of law, of course, isn't in the end a question of balancing. I mean, the question of law is a question of law, and the court's going to have to come to that conclusion. There may be some mood music in the background as to look what the Italians have done, look what the Belgians have done. Ultimately, so what, one might think, because the court's got to deal with it.
The reason why you want to uphold the Italian decree, as I think you've accepted, is you want that to weigh down your side of the scales.
We want to be able to show the arbitrators and the English court in the bonds litigation, although of course the banks can do this for themselves, that's the conclusion that the Italian authorities have come to, just as the other side.
But if you are trying to make your side of the scale heavier than the other side, why aren't you impairing the payment of the bonds?
Well, we're assisting the tribunal or court, which is charged under the relevant agreement with deciding that question, by putting in material which they might or might not find persuasive or in any shape, size or form relevant to resolving the issues. There's nothing wrong with that. That doesn't cut across the arbitration agreement or the jurisdiction clause. It's on the contrary. Those proceedings are underway, are being litigated, and all of the issues that the other side had, the reasons why they went to Mr. Justice Butcher and the reason why they were concerned with these proceedings that my clients were contemplating before His Honour Judge Pelling, was that they would impair, inhibit, trample on the toes of the very contractual bargain that the parties had made in the arbitration agreement. But what's happening in the public law proceedings simply doesn't do that. It simply doesn't touch on that at all directly. My friend says, well, it doesn't matter whether it's direct or indirect. He's right, of course, that it doesn't matter whether you directly or indirectly interfere with the bargain, but there's no interference with the arbitration bargain. The arbitrators have got all the issues they should have before them. They've got no issue estoppels cramping their style, cramping the style of either party. There can't be. They can resolve all of those issues. And the idea that my clients are in contempt of court by leading the cheering in Italy for the Italian regulator, it is, with respect, rather odd.
Yeah. I think my lord had a question.
So, and then just to, yes, if your lordship take the my learned friend's skeleton argument for today, I just want to make 3 or 4 points in relation to this. First of all, you've got the point that they say this in the respondent's notice as well, very briefly, that the breach of the arbitration jurisdiction clause is irrelevant, they say. Well, you've got my submission about that. Can I ask you to look at paragraph 14 of this skeleton? My learned friends say, Tecnimont's last sentence, Tecnimont's arguments based on provisions contained in the underlying contract are a collateral attack on the ASI, which has not been appealed. No, not a collateral attack. Nothing to do with appealing. It's a question of properly
Which paragraph
construed.
is this?
14, my lady.
14.
Of the other side skeleton for today. Paragraph 14, page 5. We're accused of collateral attack on the ASI. Last sentence, my lady. Paragraph 14, page 5. Well, we're not collaterally attacking it. We are properly construing it. And the anti-suit injunction isn't some freestanding document. It's necessarily underpinned and informed by the jurisdiction clause in the arbitration agreement. And Mr. Justice Butcher and Mr. Justice Bryan and His Honour Judge Pelling didn't make any freestanding order. They made an order because it was based on one or other of those agreements. And my learned friends also say, in the skeleton at paragraph 13, the paragraph before, they say, second sentence, the sole plausible purpose of Tecnimont's intervention, as above, is directly or indirectly, not only to bolster its arguments in the bank proceedings, which only concern payment under the bond, and the arbitration. Pausing there, well, all right, so far, but also to render the relevant jurisdiction and arbitration clauses ineffective. No, that's not what we're doing. Even if the first half of that sentence could reasonably be said to be an approximation to the facts, it's the second part of that sentence which is critical. It's the second part of the sentence that's wrong, and it's the second part of the sentence which demonstrates why this attack or this attempt to put my clients in contempt of court for breach of the order is wrong-headed. The issue in Italy wasn't a product of the contracts at all. Then, penultimately on my learned friend skeleton, paragraph 52, at page 15, they say, this is under the heading, the purpose of Tecnimont's participation in Italian proceedings. They made the point about continue or commence or pursue. And then paragraph 51, it's irrelevant that the outcome of the Italian proceedings would not directly restrain payment of the bonds. The ASI is not so limited. Rather, it prohibits the pursuit of proceedings where the purpose is to restraining or otherwise impairing payment of the bonds. As Tecnimont relies on the decree in the bank proceedings, Tecnimont must believe that the decree prevents or at least impairs payment under the bonds. Well, that just doesn't follow. The decree clearly doesn't prevent or impair payment under the bonds. What prevents or impairs payment under the bonds will be the decision of the English court in due course, depending on what's said. Then they go on to say, our reliance on the decree in the arbitration supports their position. It demonstrates that the dispute between the parties about ownership and control falls within the scope of the arbitration clause and is before the arbitration tribunal. And one has to unpack that sentence, the dispute, and you've got my submission about what's going on in Italy, and it's different from what's going on in the arbitration here. And then in paragraph 61, finally on this, this is the paragraph that I've dealt with this. I think this is the paragraph where we refer back to paragraph 43 of Mr. Justice Henshaw, which we've looked at, where my learned friends, helpful, from their point of view, latch on to this paragraph in the judge's judgment, and they say it makes no difference. The Italian proceedings are a public law dispute within the province of the Italian court. Well, it does with respect. And then they set out a paragraph 43. But the judge was wrong in their submission to find any inconsistency between the Italian intervention and the arbitration agreement. And if we go back to that paragraph of Mr. Justice Henshaw again, just one more time, paragraph 43. This is in the code funding at tab 7 at page
77.
77. I'm very grateful. I got there eventually. 77. The last part of this paragraph. If we just pick it up again, it is true, in the middle of the paragraph, it is true the issue will still remain to be determined by the arbitral tribunal or by the English court to the extent that by the parties' agreement Tecnimont is participating in bank proceedings. Then this sentence about the arbitration agreement also entails the party will not seek to litigate issues abroad as a preliminary to in order to deploy as evidence in the arbitration agreement. Well, one thinks about it. There are at least two reasons why the arbitration agreement can't, in our submission, properly be understood as precluding the litigation by one party of an issue abroad that may or may not have evidential weight in the arbitration. The first is that an issue that goes to a matter of evidential weight may arise between a party to the arbitration agreement and a non-party to it. Well, here, between my client and Agro, or perhaps even one might characterise it as being an issue with the Italian regulator, albeit my client wants to uphold it. A dispute between Eurochem Agro and Tecnimont as to the validity of the Italian decree isn't something that falls within the arbitration agreement, not least because it's not a party to the arbitration. And in any event, the validity of the Italian decree can't sensibly be said to be connected with the contract to which my client is a party. And that's, in the end, that's really, in the end, the critical question. Because we know that these arbitration agreements are concerned with the dispute arising between the owner or one or more contractor in relation to this agreement, or in any way connected therewith. That's really the question. And in my submission, what's happening in Italy is not connected with or in relation to the agreement, and therefore it's not within the scope of the arbitration agreement. And if that's right, then this appeal must succeed because the learned judge came to the contrary conclusion. So there's no dispute. The intervention isn't inconsistent with the arbitration agreement, and the fact that the Italian proceedings may or may not be useful in evidence in the London proceedings can't catapult those proceedings into the scope of the arbitration agreement. And as I've already submitted, the Italian intervention can't conceivably be said to be based on the bonds or a contractual or quasi-contractual claim relating to the bonds. Well then, friends, going to get home, if he does at all, on the arbitration point. And if he doesn't get home on that, then the appeal's got to be allowed because everything falls into place from my point of view. So the intervention falls outside the scope of the anti-suit injunction, and that's really as far as we need to go. But I've also got, as you've seen from the skeleton argument, there are some subsidiary points which we've dealt with in the skeleton about whether we are pursuing proceedings in Italy. And if I'm right about that, and my respectful submission, I am, for the reasons we give, the judge was wrong, then that would be a further reason why the appeal must succeed. And in any event, the proceedings in Italy, of course.
So what you've just said is that if you're right about the scope of the arbitration agreement, then that's the end of the appeals allowed. So you say that the form of the injunction ought to be interpreted so as to conform with and go no wider than the scope of the arbitration agreement?
No, not quite. I mean, that would be, if that was the answer, that would be great. But no, not quite. That's not quite my submission.
Right. So then why do you say if you're outside the scope of the arbitration agreement, that's that?
Because you have to construe the words used in the order, which I accept don't precisely channel the words of either the arbitration agreement or the jurisdiction clause. And that would be a very unwieldy order to set all of that out in the order. What you have to do is to ask yourself, what does this order mean? What's its scope? And does the alleged act of contempt fall within it? And the answer to that is no. It doesn't involve rewriting the order. It doesn't involve saying the arbitration, the order needs to be amended in some way. You ask yourself the question, is what's happened in Italy what this order was designed to stop?
This submission, I obviously, if I may, you've taken us to the authorities, it's all very helpful, but this submission, taken at its highest, has incredibly far-reaching consequences. Does it mean if an order is plain on its face, and we don't get involved in ambiguity, it's plain on its face, nevertheless, one has to go back to the underlying submissions and the ruling to which it gave rise in order to understand whether there's been a breach of it?
No, which is why Lord Sumption couches his remarks in the way that he does. No. But where you've got an order which would be, let me start that again. If the other side had come to court,
If the what?
if the other side had come to court before Mr. Justice Butcher, asking for an anti-suit injunction only because of the contemplated intervention in public law proceedings in Italy, and had got an order to that effect in those clear terms, that would be fine. But they wouldn't have got an order.
You've made that submission. Just stand back for a moment.
Yes.
Why, if the order is plain on its face, what makes this situation special so that we have to go back to the underlying ruling and the submissions made to understand what the unambiguous words mean?
First of all, the observations of Mr. Justice Richards, which is that in the injunction context, you're clearly here dealing with
right. So one point, what makes it special to start with? It's an injunction with a penal notice.
Yes.
Yes.
And so it's to be restrictively construed. So the court should be slow to conclude that something has been done which inhibits something which doesn't actually inhibit that which the order was trying to protect.
And the second point, which may be related to my Lord's question, but what do you say? What do you say the words should say? You say you're not trying to rewrite paragraph 2. You don't need to. I mean, do you have a construction or better wording for us that is consistent?
Can you tell me where I can find the order?
I'm sorry, Lord.
Where can we find the order?
Yeah, it's in the supplemental one.
The order that's
Front of supplemental bundle 2, a B, I think.
Well, that's Mr. Justice Bryan.
We've got Mr. Justice Butcher and Mr. Justice
Tab 9.
Bryan's
No, it's 5.
orders.
That's Bryan.
I can't find the order of Islam Judge Pelling at all. The one that we've actually been found to be in.
I'm not sure I can. I've been taking Mr. Justice Butcher's order on the basis that the wording doesn't change, so it doesn't matter.
It's a bit odd to be asked to construe an order and we haven't got it.
Well, we know what its terms are.
Well, only if it was repeated word for word.
It's continued Mr. Justice Bryan's order, which is at tab 5.
That's right.
Okay.
That's right.
So you're inviting us to construe what's at tab 5.
In effect, yes.
And what do you say
Should say.
clause 2 means?
Clause 2 means that the defendant can't commence or pursue any claims anywhere which would be inconsistent with the agreement that it made in the arbitration agreements or bring any claim which relied upon the bond contracts in the quasi-contractual way. In other words, anything which undermines the jurisdiction and arbitration agreements. That's what this order is focusing on, and that's what it means. Now, obviously, the order has to be drafted in a way that the parties can understand in a relatively constrained way that we have in an order. But that's what it means, and that's why A, B, and C, proceedings brought by the defendant in the courts of England, arbitration, and with written consent. All of that's telling us that the defendant mustn't pursue or commence any claims which would be inconsistent with the arbitration and jurisdiction agreement, which would apply, which would have been the case with the applications they were contemplating dealt with by His Honour Judge Pelling, was the case in relation to the steps that were taken in relation to the first project, where the order obtained from the Italian court. But all this court needs to do is ask itself whether the intervention in Italy falls within these words, and it doesn't fall within. Even if the words are clear, what's happening in Italy doesn't fall within them, in my submission, because we haven't commenced or pursued anything, and they're not for the purpose of restraining, delaying, or otherwise impairing payment under the bonds.
What does impairing mean?
Inhibit. Means inhibit. And there's nothing restraining, delaying, or inhibiting the payment under the bonds, because the payment under the bonds are the focus and subject of the English High Court proceedings. And that court will come to its conclusion in due course about the payment under the bond. And nothing my client is seeking to do in Italy is restraining, delaying, or otherwise impairing them. The purpose of the proceedings is to uphold a public law order, which my clients consider, rightly or wrongly, may or may not give some material which the commercial court may or may not find useful when it makes its decision about the payment of the bonds.
Is there a difference between the purpose of the proceedings and your purpose in joining in the proceedings?
Yes.
Which does this refer to?
Well, this order is concerned with the purpose of the defendant.
Yes.
Obviously.
Yes.
Obviously. I mean, obviously. But there's clearly a purpose between. There's clearly.
You can characterise the proceedings. The purpose of the proceedings
yes.
has been to decide whether the
yes,
public law decree.
I accept those things. I accept that.
You accept that it's the purpose of the defendant.
Yes, I do accept that. My submission is that the purpose in joining the proceedings isn't to restrain, delay, or otherwise impair or inhibit the payment under the bonds. It's to uphold a decision which might or might not be useful for the tribunal, which is going to decide about the payment under the bonds. It's completely different from proceedings which put a spanner in the works of the commercial court.
Well, you're going to use the Italian decree, assuming it's upheld, as material with which to attempt to persuade the English court and all the arbitrators that Eurochem North-West is equally sanctioned. Well, why isn't that? In other words, it's going to make it more difficult, or at least you hope, your purpose is to make it more difficult, i.e. impair the High Court from deciding the question in Eurochem's favour.
Well, I don't accept, Lord, that taking those steps is something which is impairing anything. It's not suborning the role of the judge. It's not impairing.
No, it may not do. I mean, I may have a bad cut on my leg, which makes walking more difficult. I can still walk, but my walking is impaired.
Well, my lord, I don't accept the characterisation. I accept what your lordship said a minute ago about the use which my clients want to make of the Italian decree if it's upheld. But I don't accept that that's properly to be characterised as impairing or an attempt to impair the payment of the bonds. It's simply material that's put before the tribunal charged with deciding whether those bonds should or shouldn't be paid.
Is it your submission that restraining, delaying or impairing the payment of the bonds means that the Italian court, that's what they're doing, they're stopping payment or delaying payment or in some other way, and the Italian court's not doing any of that?
No.
So, well, that really identifies a dispute between you, because the way in which Mr. Justice Henshaw saw it and what Mr. Fenwick asks us to uphold is the practical effect of your successfully intervening in Italy and upholding the Italian order is to make it more difficult for them to obtain payment under the bonds in the arbitration and in the English proceedings. And that's an impairment. Whereas what you're saying is you have to look at what the proceedings do, and the proceedings don't have anything to do with the bonds.
That's right. And moreover,
is that really the issue?
I think it is. And moreover, the other side accepts or suggests that what happens in these other regimes in Germany and Spain and Switzerland and so on isn't binding. It doesn't resolve anything. It's not just stuff, but it's relevant material, background material, which may or may not be used by the entity charged with making the decision, the judge or the arbitrators, to come to their conclusions. And putting that material in front of them in a way which hasn't trespassed on any jurisdiction agreement, hasn't been obtained by some impermissible backdoor in some impermissible forum, putting that in front of the court, that's not impairing the payment of the bonds, that's helping the court to come to the correct conclusion. And both sides are up to the same.
Yes, but if the correct conclusion is that the bonds won't be paid, that has prevented the bonds from being paid.
Well, I don't know what's going to happen to the Italian decree. The other side want to put before the court the decisions of the regulators that are in their favour. They want to overturn this one and put that in front of the court in order for the court to decide whether the bond should be payable. That's not whatever the opposite of impairing is. That's not facilitating the payment under the bonds as such. It's simply putting material in front of the court that's got to decide. And on the other side of the coin, putting material before the court that's got to decide, which might, if it's given any credence, persuade that court not to order payment of the bonds. That's not impairing payment. It's facilitating the resolution of the question of justice. But I think that's. I see the time.
Yes. Well, I was going to ask you, how are we doing for time?
Well, I think I famous last words. I think I've got no doubt more notes I haven't dealt with, but I suspect you've got the thrust of my submissions. Can I check with those behind me over the short adjournment, and if there are any sweep-up points, deal with them in 5 minutes at 2 o'clock?
Yes, that's fine. As long as Mr. Fenwick has time to make his submissions, that's fine.
Well, I'll be, if I say anything more, apart from asking for any questions from the court, I'll be very brief.
All right.
Have you finished on the application to vary, or is that being pursued?
This case is really about what the order means.
If it's going to be pursued at all, we would need to know, I think, at least what form of variation you're pursuing.
Well, there was a mistake on our part.
And if it's going to be abandoned, then it would be helpful, I think, to have that confirmed one way or the other.
I'll deal with that, Lily. Yeah, I'll deal with that.
Right, 2 o'clock.